good? All right, one more case? Okay, last case. We'll just plow right ahead here and go forward. Case number 22-688. Jason Carberry, co-guardian of the person, Rustin Carberry, the ward, versus Maya Robinson, who's the other co-guardian of the person of Rustin Carberry, the ward. All right, counsel, whenever you're ready.
Good morning, may it please the court.
Yes, sir.
I'd like to reserve 5 minutes for rebuttal.
Very well.
My name is Ernest Myers. I represent the appellant in this case, Jason Carberry. And we are here today requesting that this court reverse the two orders of the lower court. The first that denied his petition to remove Ms. Robinson as co-guardian of the person of Rustin Carberry, and also denied his petition to be appointed as guardian of the property of a ward.
Mr. Myers, what's our standard of review in this case?
Standard of review in this case is going to be abuse of discretion.
That means a lot of deference to the trial judge.
It certainly means a lot of deference to the trial judge, and
we shouldn't be reweighing the evidence.
You shouldn't be reweighing the evidence, but certainly this court should be taking a look to see if reasonable people would come to the same conclusion that the trial judge did.
The ward is how old right now?
The ward is 23,
All right.
will be 24 in September.
And he got tragically hurt when he was 4 years old.
Just
basically can't
Just
take care of himself at all, can't walk, and has to be fed by a tube and all that.
That's all correct, Judge Lambert. Just before his 4th birthday, there was a tragic accident. He cannot feed himself. He cannot even roll over. He cannot breathe without the assistance of a tracheostomy tube. Cannot communicate.
And your client's the father and the appellee's the mother.
That's correct, Your Honor.
And so guardian of the person is you're all the ones who take care of it.
That's correct.
Right.
Getting to the point of this case, where the focus really needs to be, and why it is that the appellant is saying there was error below, is it has to do with the focus of this case. And the focus here has got to be on Ms. Robinson's actions as guardian, the fiduciary role as guardian, as opposed to her actions as a caregiver. And the two are very different here. This isn't a child custody case where you're taking a look and seeing whether or not Robinson was a good caregiver, was an adequate caregiver. The question is whether or not she fulfilled her fiduciary obligations in this case.
Fiduciary, it's a duty of trust.
Absolutely, Your Honor. It's a duty of trust. And that is where Carberry believes that Ms. Robinson has fallen short. And there were several instances, the most egregious of which has to be the embezzlement of over $16,000 from the ward's assets. The ward has...
She did that over a course of time. Right?
She did that over a course of a fairly short period of time.
Different transactions. It wasn't one $16,500 taking.
No, Your Honor. There were actually 8 separate instances. And what happened at the time was that Ms. Robinson would pay for expenses, submit them to this special needs trust, which would then repay her for the expenses that she expended. So what she did, though, is she didn't just submit bills to the trust and say, hey, I paid this, please pay me back. What she actually did is she took the bill. She wrote on the bill, I paid this as of X and such date. She wrote a check number, which she completely made up, where she wrote down a credit card confirmation number, which did not exist.
So she said, please reimburse me for this, and she didn't really pay.
Not only didn't she really, that's correct, but not only didn't she pay, but she actually made notations on the bills themselves that were lies in order to convince the trustee to pay this. So this wasn't an accident. This wasn't, I have a stack of bills that I paid, that one shouldn't have been in the pile.
Right.
This was actual intent.
Calculated.
And similarly, something I think that everyone in this courtroom would understand is that if a lawyer wound up embezzling $16,000 from their trust account and got caught doing it, and then their mother paid the money back, which is kind of what happened in this case.
Well, she paid the money back, though. Miss Robinson paid the money back.
No, her mother paid a good portion of the money back.
Right.
She paid some of the money back. Her mother paid the rest of it back. But would the Florida Supreme Court take a look at this and say, "Oh, well, it's a good lawyer, so we're just going to let him keep practicing law"? Not when you violate your fiduciary obligations in that way. And the Florida statutes, when it comes to guardians, very specifically require that guardians do not embezzle money from their wards. And so what's happened here in this case is the appellee, both below and here in this court, very wisely, I believe, has tried to deflect off of that. Oh, well, we stipulate that the money was taken, but it was put back, so everything's okay. The appellee repeatedly attempts to argue that Robinson was not unfit as a caregiver, but makes no attempt to try and say that she acted as a proper fiduciary, because there's no doubt that she didn't act as a proper fiduciary. And that's why reasonable
So you're
people...
saying that she was fit as a caregiver.
I think so.
You're saying that's a non-issue.
I
Is that your point?
That's exactly what my point is, Your Honor.
Right. Is the trust in arrears as far as any expenses now for the medical care of the ward?
The trust is not in arrears for medical care. The trust is in arrears with regard to the legal expenses it had to incur in order to get the monies that were embezzled back. They hired a law firm. There were letters that were sent out. And when she was caught, she then agreed. She never even argued she didn't do it. But when she was caught, she then agreed to enter into a payment plan. She was receiving a salary, so it was an automatic deduction. And then at one point, her mother paid the rest of it. But there was expenses with regard to that. There was also expenses that the trust has expended with regard to, there was a mortgage that the trust gave to Ms. Robinson in order to get a house and make accommodations for the ward, and that mortgage went into default, and there was almost a foreclosure, and there was expenses involved in getting that ready to go to foreclosure. It never went there.
About this. Was this trust something that was created by the parents?
There was a recovery as a result of the accident.
They settled the plan. And,
correct, and as a result, there was a special needs trust that was then set up.
But that was something that the parents said. It's not just a trust that materialized somewhere. There was an intent.
Yeah,
to
so
have a
it was,
trust do a special needs trust. So
it is a special
they
needs
used
trust.
a lawyer to get all that set up.
Yes, and that was all set up many years ago.
Right.
And what happens is the guardianship only came about once the ward reached the age of majority. And while he was a minor, they didn't need to actually have the actual guardianship. Yeah. But once he became an adult, that needed to happen.
It's his stuff.
Yeah, exactly.
It's his money.
It is.
He doesn't have the ability to do it because of his condition, but it's actually the money for his injuries, and the trust holds his money and provides for him from the sum.
Yes, absolutely, Your Honor. And what happens is, taking a look there, it surprised to me that there really wasn't a lot of case law on this sort of a thing, although I guess it just doesn't occur very often. But the case that I guess is most on point is the McBride case out of the Supreme Court back from 1940, where you had a guardian that wound up mismanaging funds. And the Supreme Court, talked about that guardians or trustees in the fullest sense of the word, held to the strictest accountability for the funds of the ward. And in that case, the Supreme Court actually reversed a trial court who did not remove the guardian. And
well, let me ask, getting back to what Judge Wallace asked at the start, Section 744, 474, it says a guardian may be removed for abusing her powers or for the wasting, embezzlement, or other mismanagement of the funds of the ward's property, which is basically what you're saying. That's what happened here, and doesn't seem to be a dispute. I mean, it was repaid, but that doesn't mean you didn't embezzle. I mean, a bank robber doesn't get to come in and say, "Well, I'm going to give you all the money I stole, so don't charge me with a crime." And I'm not saying that she did. That's maybe not a good analogy, but basically, she embezzled, she paid it back, and then the father is pursuing a claim saying, that's pretty bad. We need to remove her from the guardian of the person. But the statute says may. So may, that means the judge can or can choose not, a trial judge can or can choose not to. And obviously here chose not to, even though this is one of several circumstances you think humanly justifies it. Why is that not a discretionary call that whether we would have done something different? That judge sat and listened to whatever was going on regarding the care that they each provided for this child, tragically injured for all these years, and decided not to remove her as the guardian of the person. Why is that not something we have to defer to?
Sure, and let me answer your question. It's going to take more than just a simple yes
I know,
no.
I'm getting to be a worse and worse witness the older I get. I go run on questions. But go ahead.
But that's
as
okay.
best as you can
As best as I can.
Yeah.
Again, Your Honor, I want to make sure that the focus here is not on the care being given to the ward. The issue here is Ms. Robinson a proper fiduciary, a proper guardian? The statute that you referred to lists some 20 different, 21 different things that a court may, as you put it, remove a guardian
the
for.
legislature put
That too, right, that the legislature
They tell me
said-
I can't write statutes and stuff like that, and that supremacy of the text thing.
Correct. And, in one particular circumstance, for example, one of the items under there is failure to comply with any order of the court, which in this case we believe that Ms. Robinson failed to do as well. But regardless, if the statute said, well, you must remove a guardian if they fail to comply with any order of the court, there could be a very minor issue that does not rise to the level of removing a guardian just because of the failure to comply with a court order, perhaps in some small way. So the legislature is giving the court a degree of discretion. However, in this case, there is at least 5 of the elements that Ms. Robinson violated. There was fraud in obtaining the appointment. There was abuse of her powers.
Well, let me ask, do you place any significance on the fact that this is the guardian of the I mean, it'd be one thing if she was the guardian of the property and saying, well, maybe you ought not to be doing that because you're taking the child's money and using it not for the child's benefit. All right, so she's not asking you the guardian of the property. In fact, she says, we got to trust and that's fine, let them do it. I'm the guardian of the person. I'm the child's mother. I have been the primary caretaker of this significantly handicapped, disabled child, through no fault of the child, for all these years. Don't remove me now as the mother to be the guardian of the person. I mean, and your client still keep. I mean, I know she sued you to be removed as well, but she's not pursuing that today.
Your Honor, in this case, my client is not saying that Ms. Robinson can't have some custodial authority over the ward. That seems to be the issue here, is that everyone seems to think, the trial judge seemed to thought, well, it's good that the ward stays with the mother. Mr. Carberry is not saying the ward can't stay with the mother. They're talking about perhaps changing how much time each has with the ward.
She has more time.
Right now,
and that was kind of by agreement, wasn't it?
yes. Okay. Right now she has more time, and my client has asked that he would have more time if he was going to be the sole guardian, but not taking him away from her. Okay, so the issue isn't does she not get time to spend. The issue is, should the court countenance her actions as being a court-appointed guardian in this case? And there's another statute I think that is important, which is the exploitation statute, which says that guardians are not allowed to exploit their wards. And the statute gives examples which, quite frankly, the appellees seem to use as a checklist. Can't commit fraud in obtaining the appointment, can't abuse powers, and can't embezzle or intentionally mismanage assets. That's exploitation. That is forbidden. That is what the appellee did in this case.
What was the question on the application as far as for the appointment that you said constituted fraud? Was the question, have you ever been arrested or have you ever been convicted?
Arrested, Your Honor. Arrested and or charged. And she was both arrested and charged. The argument was, well, I thought because I did a pretrial diversion program, I didn't have to report that.
Well, but she said more than that, though. Didn't she say, my lawyers told me I didn't have to do that anymore. They got a pretrial diversion. I guess she must not have prior record. That the felony theft was resolved, and so it went away. And that was many years ago, which your client was aware that she apparently had been charged with that. And so he was aware when she applied as co-guardian with him. And so the trial judge, I think, basically said, that's her explanation. So I don't think it's fraud, or I don't think it's enough. I don't think it's enough to remove her because she was incorrect on her application.
And I think that's what the finding was. However, even if she was told that, it was wrong, because the sealing statute specifically says even if a matter is expunged, you cannot deny it on an application for guardianship. very specifically says so.
But she was told by, according to her, she was told by a lawyer, and she had a lawyer, I guess, help prepare the paperwork for the petition to be appointed. So
yes,
presumably they went over that. I mean, I know it's not per se part of the record, it's probably confidential to me, but I mean, okay. So in her view is I go to lawyers, I did this, they tell me it got resolved, I don't have to put it on there, I go and fill out the paperwork to be a guardian, I answer these questions, and now I'm years later being told that that's going to be a thing that should be justification for me not being the guardian of the person of my child.
right, Your Honor, and there is at least one case, though, that supports the contention, that Johnson versus Knight case that we cited to, that says if you fail to comply with statutory requirements and you're filling out the application, that is grounds for removal. I understand the trial court did not find so, and certainly that is part of what we're looking at.
You called it fraud.
Yes, Your Honor.
Doesn't fraud require some intent? If she had the advice of her attorney that she didn't have to do this, where's the fraud?
Well, you know, there's nothing in the record which specifically says that the attorney gave her this advice. There is testimony that what she said, it wasn't her attorney. The testimony was that it was her understanding from the district attorney when the charges were being pled down that she wouldn't have to talk about it later. So I don't know if she actually got advice from her attorney. That the record is silent on that point. I know that I'm already into a bit of my rebuttal time, but before I take a seat, I would like to just address the second issue dealing with the guardianship of the property. The order finding a total incapacity removed every single right that the ward had, and then the order appointing a plenary guardian of the person only did not encompass every single right, including the rights to the property. So there is no guardian of the property. The order of incapacity said there is no alternative that we find. There must be a plenary guardian appointed, which is plenary is everything. And so there is an absence of a guardian of the property. My client filled out the appropriate application, is qualified. There is no alternative. The court already found that. The court had no discretion.
Isn't the trust the alternative?
No, the trust is not the alternative because the trust does not have the ability to file lawsuits with regard to monies that, for example, were either embezzled or costs that were out there on behalf of the ward.
I thought the trust sued to foreclose.
The trust didn't sue to foreclose. The trust looked into suing to foreclose, never got that far. And it was resolved before it got to that,
So the
to that
trust
issue.
doesn't have the ability to retain counsel and proceed? I mean, I thought part of the claim is that they need to recover some attorney fees that the trust suspended.
And the trust is not doing that, Your Honor.
Are they incapable of it, or they just make a business decision not to?
The trust doesn't have the authority of the court to be able to make that decision for the ward. If the trust thinks it's in the trust's best interest, but not in the ward's best interest, well, that's a conflict right there, but there is nobody that the court has appointed to say, this is what we should do.
Isn't there a professional company, corporation, trustee who is managing the actual property, meaning the financial assets of this trust?
They're managing the financial aspects, but the trust
They're
itself.
also bound by fiduciary requirements, correct?
They're bound by fiduciary requirements. They have not been appointed as a guardian, and there are assets of the ward which have not been gone after in order to make the trust whole. And that should be gone after, and there should be someone who can make that decision. Your Honor, I'd like to reserve the rest of my time for rebuttal. Thank you.
Good morning.
Good morning.
Thank you, Chief Judge Lambert. May it please the court, Robert Scavone Jr. on behalf of the appellee, Ms. Robinson, who's in court today with us. I want to start by saying that to refocus the court, if I
have a
can.
quick question.
Yes,
Has there been any waste that has been committed or an allegation made that the professional trustee that is managing the assets of the trust has committed any waste with regard to the assets of the ward?
No, sir. And in fact, the trustee or the trust officer testified at record, I believe at transcript 177, that with regard to appointing a professional trustee, which was one of Mr. Carberry's requests, that would actually make it difficult in the future to provide for Ruston, the ward in this case, because professional trustees are generally expensive. to pay and retain. So there was some testimony that allowed that bringing on a professional trustee would wind up actually costing money, but there was no evidence of waste on the part of the trust. But I'd like to refocus the court on the real issue here, and that's not. We understand that Ms. Robinson has a fiduciary duty as a guardian, but what's really at issue in this case is her fitness as a co-guardian of the person. The trial court heard 3 days of testimony in this case, heard that for 18 years Ms. Robinson had devoted her life to taking care of Rustin, had quit her job to do so. And over the course of those 18 years, there was the incidents that that my friend commented on about the.
I mean, and this really is a full-time job for her.
It's
in the
a
sense
full.
that the child can't get out of the bed and can't move. I mean,
Cannot do anything, Judge. And to be fair, it's a full-time job for Mr. Carberry as well. When he does have custody.
When it's his time during the week.
Yes, so there's no question here that the parents were dealt a terrible hand here when Rustin was injured. And they both have done their level best to try to care for him as best they could. But over the course of 3 days, the trial court heard testimony. And I think what I want to refocus the court on here is that this court's job is not to reweigh that testimony. This court's job is not to second guess what the trial judge did in this particular case as to issue one. What's really at issue here is whether the trial court's decision was reasonable, or was it arbitrary or fanciful. And I think that a full holistic view of this record shows that there's no way that you could say that this was an unreasonable decision.
And in that regard, if we flip the result, if the judge had removed your client, it would have been within the judge's discretion as well, I assume, based upon the investment.
Of course, Judge. I mean, you've all been trial judges. This is part of what a trial judge does, listens to the testimony and tries to come up with a reasonable conclusion. And in this particular case, the judge specifically found that removing Miss Robinson as a caregiver would be, quote unquote, detrimental to Rustin, and found that she had provided that the testimony showed that she had provided for a long-term adequate care for Rustin. That's the real focus as to issue one here, is whether or not the trial court was unreasonable in reaching that conclusion. Irrespective of the fact that she used money from the trust and claimed reimbursement for it, and irrespective of the fact that she allegedly lied when she filled out her application, those were all factors that the trial court took into consideration. And at the end of the day concluded that no, Ms. Robinson should remain the trustee in this case. So this court should affirm for 4 reasons. Number one, Mr. Carberry did not meet his standard by proving by clear and convincing evidence that Ms. Robinson should be removed. And that's a very high standard. It requires that the trial judge, without hesitation, have a firm belief that Ms. Robinson should be removed. And I think the record in this case is clear that a reasonable person would conclude that there's no firm conviction that Ms. Robinson should have been removed. Number 2, as Your Honor pointed out, 744.474 is a discretionary statute. It says a trial court may remove for a list of enumerated reasons. The trial court considered those enumerated reasons and other factors that Mr. Carberry brought to the court's attention, and on balance said no. This is not a case where someone who's provided 18 years of care to her disabled child, 12 of which, if cumulatively there was testimony that over the 18 years, about 2/3 of the time, Rustin has been with Ms. Robinson. 3, the question for this court is whether there's competent substantial evidence to affirm Judge Rada's decision in this case. And it's clear, based on the witness testimony, we had caregivers who had been with the family for, in some cases, 14 years, who testified that they did not have issues with Ms. Robinson's care for Rustin. We had social workers testify that they would visit and they had no issues with the way she was caring for him. And I'm not going to get too much into that record evidence because, again, this trial court's job is not to reweigh that evidence, but merely to point out that there was competent, substantial evidence in this case to support the judge's conclusion.
What's the time frame when the embezzlement took place? When did that
So it
happen?
occurred over a period of about a year in 2017 and 2018.
And this case went to trial in
2019. The arrest, just to let the panel know about that, the arrest occurred in 2005. She was advised by the prosecuting attorney in that case that she was entering a diversion program, that she didn't have, there was testimony from Mrs. Robinson that she was told, it's unrebutted testimony, that she was told that she didn't have to report this in the future. But again, even if we take as a given that was, and I'm not conceding that she lied in order to get appointed, but even if we consider that checking that box was inappropriate, the trial court factored that in and determined that was not a basis to remove her.
And the scenario involving the embezzlement, that at this point, she basically does not advance monies for the most part. It just, the bills go directly to the trust.
So yes, Judge.
That possibility has now been greatly eliminated.
Yes, and I was going to get into that. The way this trust is set up now, because of what happened in 2017, in large measure, the medical expenses for treatment, things like that, are sent directly to the trust. Mrs. Robinson is only responsible for what the court said are daily needs. So food, things like that, she can still seek reimbursement for. And of course, the trust has a fiduciary duty to guard against any potential misfeasance in the future.
Does the trust not have the ability to pursue a claim for fees? I mean, it seems the issue is there needs to be, according to Mr. Myers, there needs to be a guardian of the property appointed because the trust only has limited ability to manage the assets and not to go out and acquire assets that reimburse for the attorney fees that have been extended by the trust to try to recoup monies or what have you.
Yeah, I would not agree with that, Judge. The trust, by its own terms, requires that it act as a fiduciary and care for those funds.
I mean, it has the ability to bring suit, I assume.
Well, that's what I was going to point out, Judge. There are a number of Florida statutes that require the trust to take action on behalf of the ward. 736.0801 requires the trust to administer the trustee to administer the trust in good faith. 736.0809, a trustee shall take reasonable steps to take control and protect the property of the trust. Section 736.0811, a trustee shall take reasonable steps to enforce claims of the trust and to defend claims. And then finally, 736.0816 sub 23, the trustee shall prosecute and defend, including appeals, an action, claim, or judicial proceeding. So there's clear statutory authority coupled with the trust's fiduciary duty to take action on behalf of the trustee or on behalf of the ward. And in fact, that's what happened in this case. When it came to the trust's attention that there was a problem with the funds in 2018, the trust retained a law firm which sent a letter to Ms. Robinson and explained what the situation was. And in fact, informed her that once an agreement was reached to repay the trust, that the trustee would no longer take a litigation posture. So everyone is under the understanding that the trust clearly had the right to retain counsel and potentially litigate this issue had they needed to. Fortunately, that issue was resolved. So with respect to the removal or non-removal of Mrs. Robinson, issue 1, the court Judge Rada did not abuse his discretion in this case. The record, there's competent substantial evidence to support his ruling. That ruling should not be disturbed. With respect to issue 2, I did want to just spend a little bit of time on that because I think it's perhaps a little bit more complicated, but I'd start by saying that the statute that's relied upon by counsel, that's 744.331 sub 6b, which is a statute that, and I'll read it just for the court's benefit, it says that when an order determining a person is incapable of exercising delegable rights, it goes on and it says that the court shall find an alternative to a trustee or appoints a trustee. And what I think is a guardian, I'm sorry. And what I think is interesting in this case is that that actually took place. So if your honors look at record 1609 through 10, in 2017, the circuit court, a different circuit judge, issued an order finding no alternative to a guardian and appointed in a subsequent order Mr. Carberry and Ms. Robinson as trustees. So that issue 2, whether or not Mr. Carberry should have been added as a trustee, that issue has already been decided by the previous circuit judge. So I'm not really sure what that has to do now. What essentially opposing counsel is claiming is that this process had to be started anew because he's now asking to be appointed guardian of the property. But that statute doesn't distinguish between guardians of property or guardians of the person. It just says that in the event that a court determines that someone is totally incapacitated, that that court has to find an alternative to a guardian or appoint a guardian. And that was done in this case. So we have guardians. Now, that's the first issue, the first point I would make. The second point I would make is something that we've already discussed, is that the trust is in fact an alternative to a guardian of the property. The trust, by its own terms, requires that it protect the property. There's statutory obligations that the trustee protect the property.
If the trial court determines that the trust is an adequate alternative, it's actually precluded by statute from separate
That's correct.
guardian of the
That's
property?
correct. Judge, under 744.331 sub 6b, it has two options.
Right.
Appoint a guardian or find an alternative. And if you look at that order at 1609 and 1610, it specifically says, I find no alternative. And guardians should be appointed. And then in the subsequent order that very same day on November 30th of 2017, the circuit judge appointed Mr. Carberry and Ms. Robinson. So this is a case where we've sort of already plowed that ground. And I'm not aware of any distinction that would say, okay, well, when we ask to be appointed guardian of the property, that we kind of restart that process. And in fact, in this case, the judge, at least implicitly, understood, I would argue, that the trustee was acting as a functional equivalent. And I think that's why the judge in this case said, I find no basis to appoint a guardian of the property. But it could have also been because the judge was well aware of the fact that in 2017, this had already been accomplished. And this court can affirm for any ground in the record. And those documents are part of the record. So with respect to issue 2, we'd ask that you affirm Judge Rada's decision not to appoint Mr. Carberry guardian of the property. Judge, I just wanted to spend a minute or two. Ms. Robinson has also moved for attorney's fees in this case. The statute, I just want to point out a couple of quick things. Number one, this is not, the statute that governs attorney's fees in this case is not a prevailing party statute. The statute requires attorney's fees where there's been something done, as this court said in Peacock, for the benefit of the ward. The statute actually says on behalf of the ward. My argument.
The first DCA don't like what we said.
No, the first doesn't, Judge.
Don't like what everybody else but they say, right?
Right. The first has said that language is judicially created and has certified conflict. So
no, there we go again. Right?
So we await the Supreme Court's ultimate decision on that. But what I would argue here, Judge, is that Ms. Robinson's actions in this case has been for the benefit of the ward. She defended against these claims.
Well, actually, under the first DCA's view, it's easier.
It's easier because it's on behalf.
Easy for him too, actually.
Right. Yeah. It's on behalf of the ward. But for at this current stage, we have a fifth DCA case, Peacock, which says benefit of the ward.
Yeah. I mean, your position on fees is if we affirm today or whatever, if we affirm, then you guys are in the catbird seat with regard to fees because you basically have provided a benefit to the ward, keeping your client as the guardian of the person, and that they've not provided any benefit to the ward because they sought to pursue that they weren't successful.
Right, Judge. And I mean, I wouldn't say that that's my position completely. I think that's also Judge Rada's position. He determined that removing Miss Robinson would be detrimental. And I think that very word tells you that what she did here actually does benefit Rustin. I mean, she spent, as I said, 12 years cumulatively over an 18-year span.
No, I mean, if your side prevails on this appeal, then clearly fees are awardable.
That would be our argument, Judge.
And his side is, even if he doesn't prevail, the first DCA says it's arguably awardable.
Correct.
And they say that they don't like what all the other DCAs have done, saying we've been acted as judges. Not me, I was before I was there.
So if
So
the
Supreme Court's going to solve it for us, eh?
we will hope. One would
There
hope.
you go.
One would hope. If the court
So
doesn't
that's
have
our
any
job,
further
right?
questions, we would rely on our briefs and ask that you affirm as to both issues and award Ms. Robinson her attorney's fees. Thank you.
Okay, thank you. All right, Mr. Myers, the clock says 2:03, but we probably give you a little more time if you want to divert you. So.
Thank you, Your Honor. I'll try and move through this quickly. First, just to make sure that we are absolutely clear, Mr. Carberry is not asking that Ms. Robinson be removed as a caregiver in this case, and we need to be focused on that.
This is the guardian of the person.
Removal as the guardian of the person, but not as a caregiver. There's a lot of talk about, oh, she's a good caregiver, and the ward wasn't hurting her care and all that. Fine. But the issue here is, has she put her interests ahead of the interests of the ward repeatedly throughout this process? And the answer is yes, and that's why she should be removed as a guardian. In not paying some of those bills, there were medical supplies that she didn't get. There were physical therapy and occupational therapy appointments that had to be canceled because these folks were owed money. They weren't paid. Was it catastrophic? Perhaps not. But the answer certainly is she put her needs ahead of the needs of the ward. That can't happen, not in a fiduciary relationship. With respect to the issue of waste that was brought up, there has been waste of monies from the trust that had to be expended that the trust is not pursuing. It's in the record that the trust is not pursuing it, and the ward needs to have someone who can pursue it, and therefore does need to have a guardian of the person. As far as the professional
Why is the trust not pursuing it?
I'm sorry?
Why is the trust not pursuing it? In the record itself?
Not in the record, Your Honor. I do not know. As far as the appointment of a professional trustee, it was not Carberry who asked that. It was Ms. Robinson who asked that in response to Mr. Carberry's request to be made guardian of the property. With respect to 744-331-6B, what the statute says is that if there is no alternative, a guardian must be appointed to exercise the incapacitated person's delegable rights. In that order, all of the ward's rights were found to be that the ward was incapacitated, and there has been no appointment of a guardian over those rights, the rights of the property, that the court, in its order, found that the ward was incapacitated for. And the court found there was no alternative. The trust existed in 2017 at the time of that order, and it was not considered an alternative. And for those reasons, Your Honor, the appellant would respectfully request that the orders of the trial court be reversed, and Ms. Robinson be removed as co-guardian, and that Mr. Carberry be appointed as guardian of the property. Thank you, Your Honor.
All right. Mr. Myers, why don't you tell our students and everybody all about yourself?
Sure, I'd be happy to. My name is Ernie Myers. I have been an attorney since around 1992, which is probably longer than I've even been born. I did my undergraduate work at Temple University and went to law school at the University of Florida. Since practicing law, I have often handled appellate cases as well as trial level cases in civil litigation, both tort cases and also commercial litigation. I do a lot of work in federal court as well. I have had appellate cases like this one before most of the Florida DCAs, the Florida Supreme Court, and one trip up to the United States Supreme Court. I also represent lawyers in front of the Florida Bar when the Florida Bar has, I guess, charged them with being unethical or other violations.
were you the trial lawyer here, and why did you get involved in? It doesn't sound like you do guardianship kind of work. How did that happen?
Yeah, I was not the trial lawyer here, and what happens when you do appellate work, sometimes someone will come to you and say, I think that the trial court issued an order that isn't right. Can you, you have more skill in doing the appellate work, will you take it to an appellate court? And so that's what happened in this case. Another lawyer came to me, and she asked if I would help out with the case. But what's interesting is when you've tried a case, you know a lot about what's gone on. When you're an appellate lawyer who has not been involved in the case comes to you, and as you heard during our argument, there was a 3-day trial of this case. Well, we get that all printed up, and we have to read through this trial because we weren't there. And we need to find out who said what to whom and when and why in order to find out what happened. And that was part of this case.
And that's what we get as the judges too. We get the what's called the transcript of what happened, so we can read what happened in front of the trial judge and see what everybody said and see what the arguments were made, and we get the judge's ruling. It's written in a piece of paper, and that's what gets appealed, and that's what they ask us to either say, no, that's bad, please reverse it, or this side says, yeah, that's a good decision, please keep it intact. So how long you get ready? How long it take you to get ready to, since you weren't the trial judge, to read the 3 days of?
Well, yeah, I mean, back when I was doing the briefs, and what the folks out here in the gallery, of course, don't see, but what the panel has gotten is before we got here today, everybody put all their positions in writing. And so we had to talk about what happened at the trial level. We then had to argue our legal positions, and we put them in documents called briefs, but the documents themselves can often be between 40 and 60 pages long. So it took a bit of time to read through, certainly the...
So they're not as brief as they sound?
We try to make them as brief as possible, and sometimes we have to cut them down. But in any event, so yeah, it took a lot of time to read through it and then formulate the arguments, present them to the court. And then I probably spent the better part of yesterday going back over all of this, reading through certain parts of the record. The record in this case is all the papers that were filed at the trial court level. And in this case, the record was approaching, it approached 2,000 pages. I certainly didn't go through all of it, but you had to go through the salient orders and motions and petitions and things like that to be prepared to answer any questions, because you never really know exactly what the panel's going to ask.
Did we ask you questions today that you thought you were unprepared to answer? Or?
Let's put it this way. I always find oral argument to be challenging. I think that the judges during oral argument have various reasons for challenging parties on certain issues, and we as appellate practitioners certainly do our very best to be prepared for whatever questions we think are going to come up.
You still nervous when you come up in front of an appellate court, or are you past that?
I think anytime you go up in front of a court, there's always, the least little bit of anxiety. But I can tell you that, especially for the younger folks, I also volunteer for the Orange County Teen Court program, and I serve there as a judge. And we have students who are the lawyers, basically representing minors who have been charged with various crimes and the like. And I always tell them that the more you speak in public, the more that you can talk in front of people, the less it bothers you. I think they say that somewhere out there that the biggest fear amongst folks is speaking in front of people, speaking in public. And so I would encourage you, especially the folks here at high school, whenever you get the opportunity to go ahead and do it. Even if you're nervous when you start doing it, the more you do it, the easier it gets.
You get 20 minutes in front of us, and it sounds like, my God, what can I talk about for 20 minutes? But does it usually go by faster than you think?
Yeah, you're saying you get asked questions, and you're trying to advocate your position, and all of a sudden you glance down at the clock. I don't know if y'all can see that from here, but right up on the podium there's a countdown clock that's there. Kind of like you're sitting there at a football game or whatever it is, and that clock is ticking down, and you think you have all the time in the world, and you look down, and all of a sudden you're 2 minutes into your rebuttal time. You tried to save 5 minutes, and by the time you're done speaking, you got 2 minutes left. It goes by faster. I'll tell you, watching it it goes by slower. Standing up there, it goes by a bit faster.
That's true. No, all right. Anybody have any questions? Teachers, students? Anybody have any questions of Mr. Myers? Yes, ma'am.
I wanted to find out, if, the trust, if the property, was protected, how did it almost go into foreclosure?
I think there's just a little misunderstanding there. The foreclosure aspect of it, and again, we talked about it very quickly here, but it was certainly more in the briefs, is that there was a loan by the trust to the co-trustee, and it was that
To
loan.
the mother. To the mother.
To the
right?
mother, yes.
Right, okay.
And that loan went into default and almost went into foreclosure. That is, the trust loaned her money to buy a house, and that went into foreclosure. But
She wasn't paying it, and so they had to work something out. And
right.
I think the record said it was eventually sold, and the trust got its money back.
That's correct, Your Honor, and that's correct as well. So it didn't actually, there was no lawsuit about it, there was no foreclosure action, but it was working its way towards that.
So in that case, since the last, court hearing, the bills go directly to the trust now.
Some do. There are still others of the, I think it was brought up as kind of the daily expenses and things like that, where there are still expenses that are reimbursed, or money is paid out in advance, and there's an opportunity to ask for that money back. So it isn't completely in the hands of the trust.
But like the medical bills now directly to the trust and things of that nature. So food bills, I guess, the mother advances, and the father, I guess, too. So.
Can I ask another one?
Sure.
Okay. Obviously, a trustee or a guardian, gets paid, right? Okay, so, if in 2017 to how many other years, she was, she billed the trust for $16,000, wouldn't that be less than what someone that was a trustee or a guardian, a paid guardian over a trust or the ward be paid? Why was that illegal?
I'm not exactly sure about the question, but let me try and answer it this way. As co-guardian, she received the salary. The $16,000 was over and above the salary. When she was caught with the dollars, the salary was then reduced to be a payment plan so that it was pulled, a payment was pulled out of that to reimburse the trust. Does that answer your question?
Yes.
So in other words, if she was being paid $4,000 a month, then they started paying her less than that each month, and it went towards repaying the $16,500 that she owed the trust.
Did they get raises?
That's an excellent question. I don't think that's actually in the record, so I'm not entirely sure. The trust is actually earning money, though. It takes the money that it had and is trying to, it invests it in the life, it gets a return on that investment to try and maximize the amount of money that will be there for the life of the ward.
I mean, the ward was injured tragically, and there was a settlement that was paid because of the negligence that caused the damage, the injuries and the damage to the child, and that's what funded the trust. Now the trust has the money and invests it; it makes money on the money it's made. So it's
Trying to make it as you want to stretch it and last as long as possible. Obviously, everybody cares the most about what's in the best interest of the ward. Sure.
thank you. All right, Mr. Scavone.
Thank you, Your Honor. Hi, my name is Robert. I am an appellate lawyer with Florida Appeals. This is my boss, Shannon McClain, and we represent Ms. Robinson in this case. I graduated from law school in 2012 from FIU in Miami. And my undergrad is from FAU, the now famous Owls, as a result of the recent Final Four.
Should have won the semifinals.
Yeah, I don't know what the coach was thinking on that one. Not good. After law school, I clerked for 2 appellate judges, one at the federal level and one at the state level. A clerk is basically the judge's helper.
Who'd you clerk for?
I clerked for Adelborder Jordan on the 11th Circuit and Judge Legault when she was on the 3rd. Basically, you're the judge's helper. You do research and draft writing for the judge, and then the judge, after things like this, after oral argument, the judge will have a conference and decide how they want the case to come out. They'll go back to their clerks and say, whoever's writing the opinion in this particular case will say to the clerks, this is what we want to do based on what we've heard. And the clerks will write something up, and the judges will read it, make changes, and then eventually an opinion will be issued.
Well, that's not quite how we do it.
Yeah.
We do almost all of our own writing. So.
Yeah, that's true. I mean, some judges do like to do their own opinion writing. Some judges will let clerks do the draft and then edit it and change it. It just depends on the judge's personal preference.
True.
The 2 judges I clerked for would accept draft opinions and then edit them. And obviously, you're trying to write what the judge wants you to write because ultimately the judge's signature is on the opinion. So I did that for 2 years. Spent a couple years in what people call big law, working for some larger firms. Was not happy with that, and then spent 4.5 years prosecuting cases as an assistant state attorney in Palm Beach County, Florida. Absolutely loved the job, but I have an affinity for writing and researching, and we don't do a whole lot of that at the state prosecutorial level. So I wanted to make that change, and Shannon was nice enough to offer me a job, and here I am.
What is the organization that Shannon's the head of? I'm not familiar.
It's called Florida Appeals. It's an appellate firm here in Florida. And in fact, your former colleague is one of my colleagues now.
Who's that?
Judge Palmer.
2 of them.
2 of them. Yeah, Judge Palmer and Judge Patterson.
Who else? Besides Bill?
Earl
Peterson.
Earl still?
Yeah.
Good
So
for him.
we do appellate work throughout the state of Florida. Shannon is board certified in criminal appeals, and I hope to be there one day. So
Basically a law firm.
yeah. It's a law firm.
Yeah, go ahead, Shannon.
Oh,
Yeah,
of course,
go ahead,
definitely. I want.
Go ahead, Shannon. Go
Oh,
ahead.
thank you. So I'm Shannon Macklin, and my firm is Florida Appeals. I've been a lawyer for, this is my 30th year, I cannot believe it. I graduated in 1993. And when I graduated from Pepperdine School of Law in California, went to UCF undergrad, and was from Florida, absolutely loved appellate law and research and writing, and that was sort of my goal in life when I was a 3rd-year law student to get a clerkship. And so upon graduating, I clerked at the 5th District Court of Appeal for my judge, Judge Gil Goshorn, who has since passed away. But I opened, after I left there, after 4 years, I opened my own firm, it was called the Carlisle Appellate Law Firm. Built that firm up to about 6 appellate lawyers, and then in 2018, left the Carlisle Appellate Law Firm and formed Florida Appeals. And so Bill Palmer, who was a former 5th District Court of Appeal judge, and Earl Peterson, who also was at the court when I was a law clerk there, both work at Florida Appeals. And we have, I live in the Villages actually, so not very far from here. I grew up in Lake County. And so we have a quote-unquote Villages office, which is my remote.
Your dad's famous.
My 3rd bedroom.
Your dad was a famous lawyer.
We have physical offices in downtown Orlando and Fort Lauderdale. So we have 2 lawyers in Fort Lauderdale, and our appellate paralegal is in Miami and works remotely out from administrators in Orlando. Bill Palmer actually lives full-time in Arizona and works pretty full-time for Florida Appeals.
And wasn't your dad part of the people who were involved in the creation of the Villages? So, somewhat?
Yes, my dad was Walt Macklin, and his firm was Macklin Burnset, that still exists now. And he was they were the law firm for the Villages when it was a tiny little trailer park off of Highway 27.
He was. And you appear in front of us fairly regularly, don't you?
Yes, we have cases in all the district courts of appeal and of course the Supreme Court, and we went to the U.S. Supreme Court one time, which was a very exciting event. But, yes.
Not nearly as exciting as today.
Less of a hot bench.
Any questions of either of the attorneys?
Yes.
I have a question for you. Do you find yourself spending more time running a business than appearing in court?
Yes, especially with 6 appellate lawyers, and when I was transitioning from the Carlisle Appellate Law Firm to Florida Appeals, I left by myself and had 13 cases went with me. We have 100 cases at a time right now. So a lot of my work is generally what we do is when we get a case in, we decide who's the best lawyer for that case, and that they're the lead lawyer, and I'm just like the secondary lawyer. So we also take sort of a team approach to our appeals where the lead lawyer does the primary drafting, but we have meetings via Zoom, and so we go through each of our cases, and that gives that lawyer an opportunity to say, hey, what about this, or this is what their argument is, and so we're able to sort of hash through different arguments, which really helps and strengthens the briefing. Once the draft of a brief is like the first draft, then it will go to the secondary lawyer, and that lawyer will redline it, put comments on the side. Well, what about this? I don't really understand this. And then the other thing that we do before an oral argument, which we didn't really have an opportunity to do in this case because of the limited resources that are available, but generally in the bigger cases, we have moots with the other lawyers via Zoom where the oral arguer will pretend like they're in front of the panel, this panel. So that's we have a wonderful opportunity with former Judge Palmer and former Judge Peterson to be able to be sitting in a moot asking peppering questions. So
when you say moot, you mean like moot court?
A moot court where we have a pretend, we have like a run through, like a dress rehearsal, where we're able to do the oral argument beforehand, and then that way the lead lawyer who's performing the oral argument in real life gets a first shot or a second shot to have questions and be able to articulate the answer to that question better. And so when they're up here doing the real thing, they're more confident, they've potentially heard those questions before and can answer them better.
To follow up on your question, I actually think Shannon has a twin, because I'm not sure how she's able to do all the stuff that she does. She hasn't revealed herself yet, but I'm sure she's out there somewhere. Any other questions? Yes.
I was wondering, when you receive a case in, how do you make the determination whether or not you're going to decide to represent a client and accept the appeal? Is it based upon the judge's judgment or order, read through it, determine whether or not there's a question or an issue about the decision the judge has made? You probably would not make the decision after getting all the transcripts, because that would be a huge expense. You would make the decision probably just on the order.
Yeah, that's a great question. So the way that we sort of worked out in our cases, we have a retainer that, if a client, a potential client wants us to hear their appeal or see if it makes sense appeal, we sort of have 2 ways to do it. Number one, we can take an initial retainer in and it's 100% refundable and we just work by the hour and evaluate the case. Another, if the person doesn't want to invest that much money on the front end, we can just do like a flat fee consultation and assign it to one lawyer who then gets the documents that person wants us to review the documents, and then have a Zoom meeting with the client and potentially the trial lawyer and the client to determine, okay, does this make sense to go forward, especially if you're the appellant, because that person has to decide, okay, the cost-benefit analysis of moving forward, what is the potential chance of success on the appeal compared to how much money is it going to cost you to go forward with this appeal if it's an hourly type of case. So that's why generally the appeals are expensive, because they take a lot of time to do. And so a lot of times the cases that we get involved in are larger cases monetarily or very significant emotional cases. We handle a lot of family law appeals, and like, for instance, this is a very emotional case where, you know, has high stakes, emotionally, and financially, and so, that's sort of how we do it. And then, but if you're the appellee, you have the appellee has a duty to protect the trial judge's decision, unless there's, you know, concession of error.
And you're the appellee today, so you
Yes.
you like what the judge ruled below, and so you would like us to
We want that,
keep
we
it
want
the
them
same.
to just leave everything the way it is.
So tell the student how much attorney fee hourly rates are in case they all want to be lawyers. Right?
Well, I couldn't afford me. My hourly rate is $650, and Robert's is $400. And that was one of the reasons why Robert was assigned the case, is because his hourly rate is lower. So that enables more work to be done in the case at a lower rate. But our two retired appellate judges' hourly rate is $950 an hour.
Wow. We get paid more as a retired appellate judge than we do. Yeah. How is Earl? How's he doing?
You got any other questions? Been sitting here, I've been watching from the back. This side's been sitting here forever. I haven't seen one yet.
What are you gonna have for lunch?
Probably something fast, because I live down in Broward, so I've got a 4.5 or 5 hour drive ahead of me. So probably something quick and just get on the road. Coffee for sure. What else? Don't be shy.
Well, let me ask, anybody want to ask us judges any questions?
Yeah.
Besides the lawyers here? Besides the lawyers here. Yes, sir. We're actually going to go to the, I think the Marion County Bar Association is having a lunch here at the jury assembly room, so I think we're going to go down there and visit. Unless we're excluded or something.
I have a question. What do y'all like better, trial work or appellate work? Appellate work?
Yeah, I mean, as I've gotten older, it's, I was more of a hard charging trial judge, and I spent a lot of lunches and a lot of late nights working to keep current and keeping my docket ahead. And I don't know at age 66 I could have done the pace that I did many years ago. And so this gives you time more to be reflective, and it's probably best. You have better stories as a trial judge. There's not when you're talking about abuse of discretion or supremacy of the text and all that, my wife finds none of that interesting at all. Sometimes you'd have good, interesting stories or tales coming out of trial. And when you have a very good trial go on with lawyers who are very professional, it is a lot of fun. It's rewarding. Where, you don't always have that sense of. The thing, I was a trial lawyer too, and the thing that you notice immediately is there's no sense of adrenaline when you're a judge. I don't know if that's good or bad, but it's sort of like when you're a trial, your hard charges, when you're attorney and when you're a judge, you kind of sit up there and say, "Is this almost over?" It's no disrespect. It was very good arguing today. It was fun to listen to the arguments today, but yeah, it's the thing that I miss the most about trial judges, and I was very happy to come on the appellate court after my 43 shots of trying to get here. But the judge that I replaced, or the judge that was Judge Sawaya, who was a judge from here, and he said to me, he said, "You're going to miss being a trial judge, the ability to just write your own orders and judgments and move on, because here it's a collaborative event." And as I see, I'm getting phone calls from other judges on the court today about opinions I've circulating that I'm going to have to talk about. I kind of miss the days that I could just say, "That's my opinion. I'm done. Have a nice day." So but yeah, I miss parts of the trial court staff, but yeah, I've enjoyed this over the years. I'll be happy to not be the chief judge after 88 more days.
But who's counting?
Yeah, right. I've had an extended countdown well into the hundreds and hundreds of days to go. So, but yeah,
that probably doesn't make your successor feel very good.
I don't know. They all tell you that. I mean, it's hard to explain what it is about being a chief judge that people want. I mean, it's not like I'm putting on new concrete out in the street or whatever. But it's sort of like it's the administrative stuff that's daily that you kind of want to just sit back and say, let me just not have to talk with the clerk of court or the marshal. Well, he's a nice guy here. But, let me just do my job. Let me stay in my office and do my work and have a nice day. And I hope the thing keeps going without sinking into the Atlantic Ocean. Really big elements.
Well, being a chief judge during COVID must have been particularly difficult.
Yeah, COVID, the Delta variant hit right when I started, and then they decided we should realign all the courts too, right? So I've been on that committee and all the other things. It's like, anything else you wanted me to do here? It's kind of, I won't be sad to say goodbye in the rearview window to the chief judge. I'll give Jim Edwards the chief hat, and he can steer the ship from that point forward. But yeah.
This is a very isolating job.
Yeah.
So being a trial judge, I think I went back in my application for this job and was able to, understand with the number of trials, the number of people, just in jurors alone. I think I met over 5,000 people in the span of, I was on the trial court bench 5.5 years. And then as a trial lawyer, as Judge Lambert is saying, there's a lot of adrenaline there.
Mm-hmm.
There's a lot of prep work, and then you actually go in and try the cases. And the cases that I was involved with, the shortest one was a month long, and sometimes it was up to 6 months.
Wow.
So there was a lot of work involved in that. The client didn't believe that you could work 20 hours in a day, but I proved it, and I have pneumonia, a history of pneumonia to prove it. It was one of my first trials I ever went to. But it's this job, like as a trial judge, you can take in all of the advice from your colleagues. And in Orange County, the Ninth Circuit, I had 68 other judges that were county court judges or circuit judges. I could run around and ask them, all day, how would you decide this issue? But ultimately, I had to make the decision, and it was one person. On this court, other than ordering lunch, everything is done in panels of 3 or more if the decision is an en banc decision.
Mm-hmm.
So, yes, you have to, it's been described as sing as part of a choir.
Yeah.
And you do not have the benefit of a trial, as a trial judge with time, you ultimately have to make a decision and move on.
Mm-hmm.
Where we have time, and we're looking at specific issues. So then the challenge is make sure you get it right, because there's a court up north that will tell us when we're wrong.
Assuming they accept jurisdiction.
Yeah.
Yeah, there's a stress on being a trial judge. It's the immediacy of it and the volume, especially in light of our tort reform. Apparently, we've been on Zoom meetings with the Chief Justice about how that's impacted the trial courts, just the absolute volume of cases filed before the Tort Reform Act was signed by the governor. So, you have that, but you have a different sense of stress is what we do, because at the end of the day, absent the Supreme Court, deciding differently on things we do, what we decide has a broad effect on millions of people. And so you do have a sense of, okay, there is a hyper cautiousness of trying to get these things. Watch what you write. The editing process is an interesting one about why are you using this word? Why this word? I don't say this. Let's try this. And so it gets to a point of just tell me what you want to put in. Just write it down. Put it in. But it's different on that. But it allows you to be more reflective, and that's good for the whole process. But being a trial judge, it was kind of, my son's a prosecutor here, and I was here a month ago. I don't know why I was here. Up in my wife's truck fixed this up today. But I was sat in the back of the courtroom when he was doing a trial in front of the judge, and they were having a change of plea day. And I sat there for about a half an hour, and I thought, this is mind-numbing stuff. And my God, I used to do this for years and years and years. How did I do this stuff? I said, God bless these trial judges. My God, it's a tiring job to be a trial judge.
Yeah, I found it the same way. The stress level of this job is much better. The pace is much better. I was 16 years trial judge, including 4 years as chief judge, which I wouldn't wish on anybody except him.
Thank you.
And heard all the different divisions, and I was very much burnt out at the time this opportunity came up. This has been a blessing. This was a change of pace and change of lifestyle.
Well, his father is a former judge on our court too, and doesn't work for her, but for sure. Yeah, I was the only one voted against me being the chief judge, but then I wasn't overruled. So.
Yeah, I don't think people realize how much work a trial judge does. You know, I think lay people think that, you know, they just kind of sit out there, wait till somebody objects, and then they rule and just move on. But if you've ever even, you know, just this positive motions, if you ever have sat through one of those and then afterward you hear the judge make factual findings, you know that the judge has been up there the whole time listening to everything, writing everything down. It's not.
Well, the corollary to that is the trial judges don't appreciate as much what we have to do until we actually get them up to sit with us. Now, we haven't had that ability to do that the last couple of years because of directive from the Chief Justice, because the trial courts need to have the trial judges. But I sat as an associate judge on this court many times when I was still a trial judge, and I was convinced that I became a better trial judge for understanding the appellate processes. And I appreciate it. I know I've seen a couple of my former trial judge colleagues that sat with me or sat on my behalf in the court, and I think it's I think they understand that there's an interrelation to what they do and we do in the big picture of how cases resolve. And when they get that understanding better and what we go through, I mean, you know, there's a gut reaction. If you get a PCA from us, it's like they just got the PCA machine out there and started rolling out PCAs one day. And it actually doesn't work, but there's a lot of thought processes to go as to whether it's right or not right and things of that nature. And I hope for one day that I'm not sure what's going to happen because of it's going to be all hands on deck to help the trial judges again because of all these numerous filings that have taken place. But I'd like the Chief Justice to be able to allow us to have the trial judges to sit with us because it's a learning. And conversely is to have some of us appellate judges sit as trial judges, especially the ones who haven't sat as trial judges, who have to give them a better feel as to what trial judges go through. But convincing some of them to do that is sometimes a tough sell.
Yeah, that's one thing that Judge Jordan used to always talk to us about was that, you know, his philosophy is that if you're an appellate judge, you really should spend some time handling a couple trials. Because it gives you
especially if you've never done it.
Yeah, it gives you a totally different perspective on, like, as he would say it, being in the trenches.
Amen. Any other questions, anybody?
Judge.
Yes, ma'am.
Oh.
Did you share with what it takes to be a college judge? What's the requirements to be
You're right.
You gotta be a lawyer.
You have to be a lawyer. To be on our court here, you have to be a lawyer for at least 10 years. I believe you have to live in the jurisdiction of us. I'll say that broadly. Kind of, or at least time it well. For us, it's not an election process, it's an appointment process. So, for example, we have an open spot and you have an application you have to fill out. And there's what's called a judicial nominating commission that looks at all the applications, interviews the applicants, and then sends up to 6 names to the governor's office to select somebody. And so then you go, if you're one of the 6, you go interview with the governor, and then the governor chooses one of the 6, and that's how she or he gets appointed to our court. So, I mean, there's nothing. It's not like you have to be a trial lawyer to become an appellate lawyer, that you have to be an appellate judge. You have to be an appellate lawyer to be an appellate judge. You literally, if you're in 10 years in a day and you decide that's the route you want to go, you can apply. And if you happen to get out through the Judicial Nominating Commission and the governor appoints you, then you become it. There's nothing separate you have to learn or study to do that. And then once you're there, then you're on the court, and we go through retention elections. So every 6 years after your first 2 years after you're first appointed, you're up for election, and it's either a thumbs up or thumbs down. So they vote to keep you in. I just had an election. I don't know. I think I'm the only one here. I had the election in 2022, and I mean it's an interesting process. I think a million plus people voted to keep me, and about 500,000 voted to get rid of me, and I can't explain other than about 8 of them why anybody voted the way they did. But that's the process we go through. So you kind of that's how you get there, and that's how you stay there. And obviously, you can retire or whatever. But
And if you're a trial judge, you're either appointed or you are elected, depending upon when the position is that you're seeking has been vacated. I was initially appointed to replace a judge who was removed from office. And then once you're appointed, you go a year and then to the next election, and then you're up for, you have to qualify for that position, and then attorneys can choose to either run or not run against you. In the Ninth Circuit, which is Orange and Osceola County, prior to my appointment, it wasn't a practice for lawyers to regularly run against sitting judges who hadn't done anything wrong. I was the inaugural test case. So ever since then, it seems like someone in the bar makes a decision to run against, usually it's the most recent appointee. So I had to form a committee because someone filed to run against me in 2010. And that committee raised money, got endorsements. I think they raised over $100,000 for a campaign, and that was a long, hot summer. But I won my retention election, so I'm kind of a rarity. I was appointed and elected, and then I left.
At the trial court level.
Yes, at the trial court level. But since then, it seems like in the Ninth Circuit, every election cycle, at least one attorney runs against a sitting judge. And that's kind of was standard practice down in South Florida, and it's becoming more a regular occurrence as you move north. So.
Judge Lambert, how is Judge Savoya doing?
I haven't heard from Tom for about a year. He sat with us he decided he wanted to come back and sit as a senior judge with us, and he sat with us for about a year ago, and he seemed to be doing all right. I haven't talked with him in probably a year. We don't really have that much of a need for senior judge. We now have 12 judges on our court. Before we had 11, so now we have 12. So we're able to keep up with our workload. So have you heard?
He's been filling in as a senior judge down the Ninth Circuit and trying, I think, like med-mal cases, ones that the circuit judges can't devote, 2 to 4 weeks on a trial. I've heard he's very well liked down there. They love to have Judge Savoya come and take a 4-week trial, and I think he really enjoys it.
Who is it, the judges or the attorneys?
The judges.
Yes. Okay, thank you.
So.
Anything else? Well, yes, sir.
You two have been giggling and looking at each other.
I'll defer to the students if they have questions. Yeah.
How often do you get vacation?
I'm sorry, can you hear?
How often do you get vacations?
Oh, boy.
Life on the 5th District with Chief Judge Lambert in charge is always a vacation.
Because I do most of their work. No, I guess, I don't remember my wife and I went out to Lake Tahoe in October for about a week or so when one of my nephews was getting married. So, I don't take that many vacations, actually. Maybe a week a year or so. I could take more. My wife don't want to go with me on vacation. So.
Is that an important part of your calculation in terms of what you want to do when you grow up?
Well, you have control of what the beauty of this job is you have a lot of. We're not in court much. This is not a frequent event. So, and we work at home. With COVID, kind of kept everybody home, and we've all learned to work at home. So, I come to court more as a chief judge because I think you actually have to see me over there as a chief judge. But most of the stuff we do, you can stay at home all the time. So you can work from home because a lot of what we do is just reading and writing and working on the computer. So it's a lot nicer than with the trial judges who are actually in front with the juries and things of that nature. So, yes, ma'am. Yeah.
How many hours do you typically work a day?
How many do I work a day? Well, let's see, we're on TV. I would say I work 8 to 10 hours a day. I mean, and the beauty of the job is that I can work like today. I don't know. I got up at 4 in the morning because I don't know, and so I was reading stuff before I came in today, just to be fresh and keep everything fresh in my mind as we were going to have oral arguments today. So, but I mean, there's I usually start around 8, and you kind of work your way through them. Depending if things are going on at night or not, I can work at night. But I would say 8 to 10 hours a day, and I work pretty much every day. I don't work 8, 10 hours a day on the weekend, but it's rare that I don't do something related to court work every single day. It was I was up in Michigan a couple of weeks ago on a thing, and I was visiting my sister, and so I didn't bring my laptop with me for 2 days, so I did nothing court related for 2 days, and I started envying our recent Judge Evander who retired. Started thinking, I'm getting older, and this isn't so bad that nobody's bugging me for 2 days here. So, but I don't know. I'll probably stick around for several more years before this is over.
You guys twins? So one's worried about hours, and one's worried about vacations.
Work-life balance. I mean, yeah.
If hours and vacations are important, you might want to find someone else.
I'm Christian Law from the Waugh Grant Law Firm. I got here during the second argument, and it seemed to me that all the arguments were really good.
It was a nice job today for everybody.
They were well done. But I was curious if the court, anyone on the court, had recommendations or 1 or 2 things that the court doesn't like to see in oral presentations that people could take away.
Misstate the record. Yeah, never misstate anything in the record.
Answer questions. Don't try to think more into what we're asking than we're asking. Just answer the questions. Stop what you're doing and answer the question. I know, that's if we're asking questions, that's where there's some people who have a sense of if nobody's asking me questions, I'm doing really well. That's not really always what's happening. It's usually like, okay, is this guy going to get done soon so that this case can move on because he's going to lose, kind of thing. So when we're asking questions, that means we're engaged and we want you to. These are things we want to answer amongst ourselves. So when you avoid answering the questions, or especially if I give you a hypothetical, the first response should be, that's not the facts of the case. No kidding. I just made them up. That's my fact. But there's a reason why I'm asking. So don't misstate the record. Respond to the question. Don't get emotional with us. Mr. Meyer, he didn't get up today and says, if we lose today, my client will be so sad today and he'll be crying, and you don't want that to happen, judges. Please. That's not the art. Maybe that's at trial court to talk about stuff, but that's not us. The record's our record. We have to decide, is there error that was committed, and if so, is it significant enough to reverse the case? So becoming theatrical, there's a different skill set between being a trial attorney and an appellate attorney. And I think you can't be both effectively, because I actually did both. But that stuff falls on deaf ears, and it sends messages to me as if that's your best shot, then you're telling me you really don't have much. You're trying to play on my emotion, and really, I've done this long enough, and I've seen and heard a lot of sad things. So tell me why there's error below. Don't tell me this it ain't right, Judge. Yeah. Okay. A lot of things ain't right, but
You don't see it here. You all didn't see it, but I can speak from having a 8th grader and a sophomore in high school. It's very important in the writings that are filed with the court that you proofread them. That you look for grammatical errors, and my kids bellyache to me all the time, Dad, I don't want to read this again, and it applies here too. It wasn't in these cases, but in some cases, I try not to take account and mark down and grammatical errors and diction problems and punctuation. But it's just, I don't know, it's either a curse or my personality that I just keep track of that, and that can distract from what you're trying to communicate.
One of the things I used to, when I was a trial lawyer and a trial judge and as an appellate, it's like, you need to make it easy for me to rule in your favor. Make it clear and easy for me to understand why it is that is the correct result for me to reach. Telling me, when we get briefs and there's 12 claimed errors, it's like, really? What, it was just a free-for-all down there? That judge never was a judge before, and it just was, going on. Hone it down to what's your best argument, because when you throw everything out like that, then there's a visceral reaction as a judge. It's like, okay, you're just complaining about everything. You don't get a perfect trial. None of us are perfect. You do the best you can. Don't just tell us that the judge was mad at me that day, didn't smile. The judge didn't, tell us why substantively there's some error that's preserved here and that we need to address because it's significant to this case. And I can't stress enough that it's a logic, calm, direct approach, responsive to us, and that makes our job better. Because at the end of the day, we want to provide a good product to what has been prepared in front of us to resolve. And when it's tough to read briefs, tough to understand the argument. I remember as a trial judge, one time an attorney came to me after he lost the trial and said, well, what do you think? I said, well, maybe you shouldn't be yelling at the jury throughout all this time. You're very loud, but I won't say the guy's name. It's tough to receive stuff like that and try to keep track of why it is, as opposed to this, goodness gracious, what's going on with this person?
Thank you.
Yes, sir. Anything else? All right. Well, we thank all of our students and teachers for coming here today. We thank the attorneys for putting in the extra effort to help us educate and provide input to everybody. And we appreciate being invited by the Marion County Bar. I guess we'll join you down at your bar luncheon thing or something.
All right.
Nice to meet you.
Oh.